Have you been charged with a domestic assault charge here in Virginia and you want to know what's going to happen in court? Do you want to know the procedure? Watch this video and learn more. Hey folks, James Abrenio here, owner of Abrenio Law, your Northern Virginia criminal defense and personal injury law firm. In this video, we're going to take some time to learn about domestic assault charges and particularly how do they process through the courts, what's going to happen next. Hopefully it's going to clear up a lot of questions that you may have. It'll probably even anticipate questions you didn't know to ask. So hopefully by the time you come to picking your attorney, you're equipped with and empowered with the best questions so you can make the best decisions about your case. So to help explain the legal process here in Virginia, I'm going to be using a graphic which I'm going to first pop up on the screen right now. And as you can see, this is really a flow chart that we're going to be referencing back and forth as we talk about domestic assault charges, and I'll be using this in order to hopefully educate you a bit more. So you'll see the graphic is entitled Criminal Procedure in Virginia Misdemeanor Court. So that should tell you, first of all, if you're charged with any type of misdemeanor in Virginia, typically it's going to be either going through the General District Court, which is the lower trial court, or the Family or Juvenile and Domestic Relations Court. Those both are really the two lowest trial courts in Virginia. The cases go in the General District Court especially when we're talking about an assault type case, it goes in the General District Court if the complaining witness and the accused party are not related. Whereas the domestic assault, for instance, it'll go to the Juvenile and Domestic Relations Court because the complaining witness and the accused are related. There's a familial relationship, maybe they have a mutual child together, there's significant others, and there's other specific points of the statute in order to analyze and make sure that we know which one it's going in. But if you're charged with a domestic assault charge, it is going to be started in the Juvenile and Domestic Relations Court, the lowest trial court. So as you can see there, the first number 1 box is arrest and charge. By the time, if you're watching this video and you've been charged, this has already happened. Law enforcement has either shown up to the scene of the alleged incident and either issued you a summons or brought you in before a magistrate, where a magistrate has determined your bond. Usually, if you're watching this video, it's likely that you've already been granted bond. A magistrate has determined that you probably either have an unsecured bond or given you some type of ability to get out by paying a bondsman, or you've essentially promised to come to court, or you owe money. So the next point, number 2, the second box there is an arraignment. So in most Virginia courts, particularly here in Fairfax, they have a separate court date. It's called an arraignment. It's really a formality. In this arraignment, that's when essentially the court formally informs you of your charge, and it formally gives you a trial date where the actual trial would happen, but it also formally informs you that you have a right to hire an attorney. If you can't afford one, they're going to appoint you one. You have the right to apply for that court-appointed attorney. Typically, that arraignment date, again, you're not going to be, in most instances, be seeing a judge. In Fairfax, I know, for instance, you actually watch a video. Other courts, I think Loudoun, you actually do see a judge. But in many instances, you can actually have the arraignment waived if you hire an attorney before that date, and then they fill out their appearance and they make sure that that's fine. But an arraignment is usually going to be shortly after the arrest, usually within a week or so. There's not going to be a long period of time unless there's something unusual. Right now, as I'm creating this video, there's COVID is all over the country, so there's a bit of unpredictable delays and things like that, but usually that first court date is going to be the arraignment. So you're going to want to obviously make sure when you talk to an attorney that you've clarified, is that an arraignment date or a trial date. If you have ever have any questions about whether or not your next court date is an arraignment versus a trial date, you can always call the clerk's office and just have them inform you one way or the other. That way you know. Now, the next court date is usually going to be given at that arraignment date, or your attorney's obtained it by filing his appearance or her appearance and been given it by the court. But usually that next court date is going to be a trial date, okay? And if it's an assault, domestic assault charge, as we discussed a little bit earlier, it's likely going to be in the juvenile and domestic relations court. You may be surprised that there's not going to be any other type of court date in between an arraignment and a trial date. But typically that trial date is set at least 3 to 4 weeks out, sometimes further, and that typically will give you enough time in average typical cases to prepare. If not, your attorney can always ask for a continuance prior to that court date. But that first court date in the juvenile and domestic relations court, when I'm advising my clients, I want to make sure that we're fully prepared to go to trial. And what I mean by that is, if you don't like an offer that's been given by the prosecutor, you're ready to try the case. That means not necessarily that you yourself are going to be testifying, but you're ready to put on a court case for a judge, and if you're going to be claiming that you're innocent, then we're going to be making that argument. So with that in vain, I always tell people that when you're ready for your trial date, I want to make sure as counsel that you're fully prepared to make a decision. That means that you're aware of all the different options that may happen at that trial date. That way that you're in a position to make that important decision about your case. Unfortunately, when you go to court, a lot of times it's going to be a very quick process, because in many jurisdictions, prosecutors have a lot of cases. In many instances, you're not able to work out that case beforehand. And so at that trial date is when you're going to be having all your options coming at you at once, and you're going to have to be prepared to make that decision in a pretty quick turnaround. That said, in order to prepare you for that, part of what this video and I'm intending to do here is kind of give you a breakdown about what the typical options are that are presented in a typical domestic violence, domestic assault type case. And what I mean by typical is an assault that doesn't involve serious alleged injuries. Nobody's saying that you permanently injured them or wounded them, broken bones, that kind of thing. Assault, actually, in Virginia, is to be guilty of that is actually a very low threshold. There's no requirement that you be alleged to have injured them. There's no requirement that you alleged to have caused permanent damage. There's not even a requirement that there's any visible, observable injuries. So when we're talking about the typical domestic assault case, I'm talking about those types of cases where there's not really an aggravated circumstances to be discussed. Now, if your case involves allegations of more serious injury, you're going to obviously need to speak to an attorney, and if you speak to me, we're going to have to address the unique circumstances of your case. You may even be likely facing something more serious than a domestic assault charge, maybe a malicious wounding, or a much more serious charge. But when we're talking about possible outcomes, again, we're talking about typical things, typical cases. So the next slide, here's possible outcomes, and you're going to see there, there's really, I've highlighted kind of 5 typical options that may be presented to you. Whether or not they're actually presented at court is going to depend on the facts of your case, but you need to be aware that this may or may not happen at court. Now, the first one is a continuance. And what that means is your case is postponed for whatever reason. There can be different reasons. For instance, you get to court, your attorney learns some fact that he has good cause to not have known about before and needs to investigate it, and he tells the judge, or she tells the judge, Your Honor, I need more time, so we need to postpone the case. In Virginia, that's called a continuance. There can be other reasons. For instance, let's say the Commonwealth, the prosecutor here in Virginia, didn't give you information that they were supposed to, and they realized it late. Sometimes that can cause a continuance. Let's say for good reason a witness isn't there that's needed, somebody's sick or didn't get a witness subpoena, or there's other various logistical or strategical reasons that a case may be postponed. But that being said, be aware that a lot of people come into my office, they want this case done. They want to put it behind them. They want to move on. And when I'm bringing up continuances, that inherently means that, look, your case may not be done your first trial date. I always tell people, look, If we're continuing your case, especially if I'm asking for it, that means I'm doing it to benefit you. The way I actually get paid is I charge a flat fee, meaning no matter how many court dates I come to, my fee is the same. So if I'm asking for a continuance in your case, that means I'm working more hours, but the reason I want to continue is my goal is to get you the best outcome. So if I'm asking for a continuance, it's needed. Now, the Commonwealth may be asking for a continuance. Maybe I object, but if the judge grants it, the judge gets the ultimate say on whether or not that continuance is granted. But that is one possible thing that may happen in your court date. Don't count on it, though. You have to be prepared for that first trial date no matter what, because you're never quite sure. Now, the second thing that may happen is you get offered a plea agreement that you really like. And now, one may be a plea agreement with a conviction. Now, as I said before, we're talking about options and we're talking about typical domestic violence cases. Now, this is when I'm talking about a good plea with a conviction. That's typically going to be a bit more serious than a typical domestic assault case. Let's say there's a bad injury or a bad alleged injury, or there's certainly bad facts that may make your case more serious than just a typical domestic assault. Maybe it should have been charged as a felony, but we would rather get it resolved now to avoid that felony conviction. You may end up taking a plea agreement that involves a conviction, but again, if I'm representing you, we're going to be talking about that. We're going to be talking about why we're going to be doing that and making that decision together. It's rare that I will take a typical domestic assault case and agree to a conviction unless there's something very unusual about the case. Now, the next option is what we call a deferred finding. And when we're just talking about a good plea agreement with a conviction, the reason it's rare is under the statute for typical domestic assault cases, the statute actually allows for a deferred finding. And what that means is you go before court and either you admit that facts are sufficient, that if you went to trial you would be found guilty, or you plead not guilty and a court finds that there's facts sufficient that you're guilty, but instead of convicting you at that moment, it withholds a finding of guilt against you and it doesn't convict you, and then it postpones the case. Typically in Virginia, a deferred finding is a 2-year deferred finding, meaning you're going to be placed on probation for 2 years. You're going to have to complete anger management, not violate any laws and other conditions. And if you comply with that after 2 years, the case is then dismissed against you. So you're not convicted. That in many instances can be a great result. In some instances not. Now, the reason it may be a great result is, let's say that the evidence is clear that you're going to be convicted, or you went to trial and a judge gave you a deferred finding. A conviction is better. A deferred finding is certainly better than being convicted. So it avoids being convicted on your record. Under Virginia law, if you have, I believe, 3 convictions, that's actually a felony. That third charge would be a felony, so it avoids that predicate offense. But it puts you in a better position than conviction itself. But that said, in many instances, I'm not happy with a deferred finding because it can have tangential consequences that can put you in a bad position. So the first is, at least as it stands under Virginia current law, a deferred finding is not expungable. What I mean by that is a lot of people say they want their record clean after everything is done. After 2 years in the deferred finding, they want to go back to the court and ask that they seal the records. If you took a deferred finding under current Virginia law, that is not expungable. That's always going to be on your record. And the statute is pretty clear about it. The case law is pretty clear about it. And so that arrest record is going to be there. It can have other consequences. For instance, and I want to be clear, I'm not an immigration attorney. You always need to speak to an immigration attorney about your immigration case. But as it stands today, a deferred finding domestic assault case can have serious implications on your immigration case if you're not a U.S. citizen. So you need to talk to an immigration attorney. And in fact, when I'm working with a non-U.S. citizen, I usually will co-counsel with an immigration attorney to give me that advice on what a deferred finding may or may not do on their case. So it can have very serious consequences. Let's say you have a high security clearance. A deferred finding can, my understanding, again, be very serious. Now, again, I can't advise you. I don't do security clearance checks, and my understanding is security clearance approvals are very fact-specific. There are specific attorneys that deal with that, but a deferred finding can have serious consequences on that. There's other issues that a deferred finding can have just because your record is permanent, even if there's a non-conviction at the end. But you know, you just have to be aware of that. Now the next thing is the next option, or a potential option that may be granted to you, is something called a general continuance. A general continuance is something that sounds like a deferred finding, practically speaking, but is very different. A general continuance is actually a private agreement between you and the government, and me and the government. The judge isn't made aware of it. There's no real notations in the file that if the case is continued for sometimes 6 months, sometimes a year, sometimes more, and you comply with everything according to that private agreement, the case is outright dropped by the Commonwealth, no prost. That means that they are no longer pursuing it. And in many instances, this is an awesome result. So let's say, for instance, there's a contested case where somebody's alleged that you have committed an assault, you're outright denying it. The prosecutor realizes that they go to trial, they may outright lose it. We also realize that there's always a risk at trial. So if you do community service and you don't violate the law for 6 months, that's something you're willing to do. That's something the government willing to do. So you will both get a compromise. They get to monitor you for a little bit. If you earn what the general continuance allows, it's dropped later on. And the great thing about a general continuance, if you can get it, is it is expungable. And it typically, and again, for immigration purposes, you need to speak to an immigration attorney, but my understanding is typically a general continuance will not harm your immigration situation. Again, speak to an immigration attorney. But in many instances where an offer of a general continuance is made to my client, it's going to be a unique situation where I'm going to say turn that down, because if you turn it down, then everything is back on the table, including a possible conviction, whereas a general continuance, even if it's a slower process, you may be able to earn an expungement at the end of that. That's always my goal as defending domestic assault charges, is trying to protect your record, trying to make it to where you can ultimately have that expunged. Now, I want to be clear about a general continuance. This offer, this option is the exception and not the rule. A lot of people call me, we talk, and they say, well, James, I want that general continuance. I want it too, usually. But for the government to offer that, there's got to be something unique about the case. It's rare that that will be offered. Obviously, in every circumstance, as defense counsel, my goal is to try to get you in the best position possible. And if I'm able to get this result, then that's a great result typically, and I will go for it. But in many instances, the prosecutor's just not willing to offer it. And frankly, I don't disagree with them if I was a prosecutor, because the facts don't always call for it. In fact, most of the times they don't call for a general continuance. So just be aware. Another issue, sometimes a judge will not allow a general continuance. So you just have to be aware that if that's an option, what I want to be clear is that you know the distinction between a deferred finding and a general continuance. And another thing is, when I say deferred finding and general continuance, these are really local terms of art that we use. Jurisdictions may do it differently. It may be called something different in Henrico County than it is here up in Fairfax. So you just need to be aware of the procedure. Again, a general continuance, it's a private agreement. There's no finding by the court. It's just the case is continued, and then you come to an agreement with the Commonwealth. The deferred finding is there's an actual finding by the court, and that's going to be the linchpin as to why that's not expungable. Now, the last scenario that we oftentimes see, the option is the option to go to trial, right? You get to court, the Commonwealth won't give you a general continuance. You say that you're not guilty, and we believe that the evidence is going to show it, and we're prepared to do that, so we put the case to trial. That means that I get a chance to make an opening argument for you. I get a chance to cross-examine the Commonwealth's witnesses, the evidence, and you have the right to testify. Under the Fifth Amendment, you're not required to testify, and it may not always be my advice that you testify. It's a lot of times you're going to defend on the facts of the case, but at the trial date may end up actually being a trial where different things can happen. Now, in this diagram, as you can see, we've now had, from the trial, there's different things that can happen. So there's 3 different things, okay? The first is an acquittal. What that means is the judge agrees with you. There's not enough evidence to prove you guilty beyond a reasonable doubt. So the judge said, I'm going to find you not guilty. And if you have acquittal, that's essentially the best thing that can come from your case besides an outright drop by the government. That means it is expungible. That means that you can get the record sealed. It shouldn't have any immigration consequences, or it's the least likely to have an immigration consequence in other issues, tangential issues like security clearances and housing and things like that. But just be aware that to get an acquittal, you've got to go through trial. I've tried a lot of cases and we've had great outcomes, but a lot of times it's hard to predict what a judge will do. I've had many cases that I thought I was going to lose at trial and I won. I've had many cases that I thought I was going to win at trial and I've lost, and everything in between. So just be aware that trial is always a potential. And at that trial date, I want to have my evidence ready and prepare to go to trial. If we get the other options that we've talked about before to happen, because they're in your best interest, that's great. But the way we come to the best decision about your case is we're ready to go to trial and we're ready to seek that acquittal, and we'll have a discussion about what the likelihood is in your case. Now, the next thing that may happen at trial is you get convicted, but that's actually a good result given the circumstances of your case. And what I mean by that is, as I talked about before, the good plea with a conviction, the option before. So maybe this is not a typical assault case. Maybe there's evidence that came out that you caused injury, or there's some aggravating facts about the case that may make it be that, let's say you get convicted and you don't get jail time. And we thought at trial there'd be a likelihood of you doing jail time. So that conviction's actually a good result because you avoided jail time. That may be something that presents itself. Maybe you get minimal jail time, or maybe you get a lower fine or whatever, but for whatever reason you're fine with that conviction. The next thing that can happen is a conviction with a bad result. What I mean by that is the judge finds you guilty and you don't like the outcome, right? So you want to appeal the case. So in many instances, and this comes up in typical domestic assault cases, you can actually ask for a deferred fine that we talked about before after you go to trial, even if a judge finds you guilty. But a judge has a discretion to say, no, you exercised your right to trial, I'm going to go ahead and convict you. If they can convict you, you can then appeal the case. But the judge may also say, we're going to go ahead and give you a deferred finding if you want that. And that may not be something you want. And if you want to appeal the case, let's say you're seeking acquittal and you believe you're innocent, and we talked about it after trial, we believe that, and I'm telling you at trial up in the higher court we may win, you actually need to seek a conviction from the judge. The judge has to enter that conviction, then we can appeal it. Now, as noted there, to an appeal on a conviction, it has to be noted in the clerk's office within 10 calendar days. That's not 10 business days, that's 10 days from the conviction, and then you have an absolute right to appeal. Now, when I hear the difference, people always tell me, well, James, maybe I want a jury in a case. You don't get a jury in the juvenile and domestic relations court, that lowest trial court. That's really what I tell people. That's like Judge Judy. If you want the jury, that means that you've got to go up to appeal. You don't want a jury just because you want a jury. You want a jury because you have to have one, because things didn't go well in the lower courts. You had to appeal it. And the next level of trial court in Virginia is the circuit court. So whether or not you start in the general district court or the juvenile and domestic relations court, the appeals in those cases go up to the circuit court, and that's where you can ask for a jury. I tell people the circuit court is like what you see on TV, where you have a panel of jurors, if you want one, and you can present that argument to the jury. Now, if you choose to appeal, either side can ask for a jury. Usually, if I'm appealing a case from juvenile and domestic relations court, I'm typically going to ask for a jury because we've discussed it, and under my advice, we've chosen that's the best option. Sometimes we may not want a jury because there's something unique about your case, but again, the Commonwealth has a right to that. Now, what I mean by a de novo appeal is everything starts over. So the finding in the lower court is not admissible at trial, and you essentially get a second bite at the apple. Now, the process for circuit court, it's different in different counties, so this video doesn't really cover that process, but just be aware that in order to get through the juvenile court to note an appeal because things didn't go well, you have 10 days to note that appeal. Now, if you have any other questions about the procedure of domestic assault cases in the Juvenile and Domestic Relations Court, make sure to reach out to us at www.abreniolaw.com. If you felt that this video was useful, feel free to share it. Feel free to comment here. You can also shoot me an email at james@abreniolaw.com. Now, the procedure up in circuit on the appeal, that's going to be very different depending on the facts of your case and, again, the county. So that's not really the subject of this video, but hopefully this video gave you some more information so you're more prepared when you go in to court for your domestic assault case in the Juvenile and Domestic Relations Court. If you have any other questions, make sure to reach out to us, and I hope that this has been helpful, and we'll talk to you soon. Thanks.